Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, Melinda Scott walks through a limited partnership agreement designed to run a fund. So let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen, here today with my friend Melinda Scott. Melinda, how are you today?
I am great. How are you doing?
I'm okay. Today is one of those days where we are dealing with a contract that is long and confusing, and it's that magic moment to me where I don't know something, which makes me confused and also scared and a little bit excited. So let's talk about it. The document is called the Fifth Amended and Restated Limited Partnership Agreement of Series Orion LP. What is this document, an amended and restated limited partnership agreement? What's it trying to do? When are we going to see this?
So generally, you're going to see this type of document for a fund document. So you'd see it for a hedge fund or a commodity fund. In this case, it's a commodity fund where you have the general partner, which is normally formed as an LLC, and then you have the limited partnership agreement. This is the limited partnership agreement, and it tells the limited partners, the investors, what their rights are.
All right, but this, as I mentioned, has been amended and restated. There's clearly some history here, and it shows up in the preamble, a little bit of back and forth. Can you just give me the context of who the players are here, what the amending is that's happening? Do you pull history from that bit of preamble at the beginning?
Well, you do pull some history from the preamble in the beginning. I mean, you get to know who the general partner is and the limited partnership. And generally, you'll have the same general partner for multiple limited partnerships. And you'll see an amendment like this when there's a change in the law or when there's a change in the underlying investor population that's going to be invested in this fund, if the investors need to have a change of some description.
Got it. Okay, and we're going to talk about some of that, the change in the law, because there's some of this that might not work for right now. So we'll talk about that. Let's start with number one, formation and name. It says the parties formed a limited partnership under the New York Revised Uniform Limited Partnership Act. The name of the limited partnership is so and so. What are you seeing in Section 1, the formation and name? Do you like the way they've done this?
Yeah, so generally you would form a hedge fund or a commodity fund in Delaware. And there's a number of reasons why you want to choose Delaware as opposed to New York. One reason is the ease of dissolution of an entity. To dissolve any entity in New York, you have to jump through multiple hoops. But then when you're looking at, in particular, a fund structure, where you have limited partners, where you have investors, you want to look at the underlying statutes and the laws and the case law that's there. And when you look at Delaware, you have a multitude of case law that is very specific to funds, that's very specific to business, that clearly understands the fund structure. So if there's any dispute, one, you don't actually have to go into court. You can look at the former case law to know how it's going to play out, so you know exactly where you stand. And two, if you go into court in Delaware and you have somebody that clearly understands the sophisticated structure of a commodity fund or a hedge fund, or the sophisticated structure of your company that's going to be making decisions on how this should play out. And you're not going into a local state court where this local state judge has no idea how a commodity pool operates and what half of the definitions within your document mean, and or some of the regulatory implications. Also, each state has different rules. And when you look specifically at Delaware has rules that are very friendly to funds. And that's why you see almost every hedge fund in the country or every commodity pool in the country being formed in Delaware.
Got it. All right. These guys are hanging out in New York, and here's what they're doing. If you look in Section 3, it's titled Business. It says the partnership's business and purpose is to trade, buy, sell, or otherwise acquire, hold, or dispose of interests in commodities of all descriptions, including future contracts, commodity options, forward contracts, and any other rights or interests pertaining thereto, including interests in commodity pools. It has some language about what they're not doing. One of them says they're not here to make loans. What do you see in the description of the business? Do you think it lines up with their intent? What are they trying to do here?
So here, just based exactly on what they said, they're likely a commodity pool or a CPO, a commodity pool operator, which is a regulated entity. And because this is a regulated entity, I would reference who your regulators are. It's the CFTC, the Commodity Futures Trading Commission, or the NFA, the National Futures Association. So basically, you're going to be looking at the regulations of both of those entities. And one thing I would also have within this section, because it specifically states that you're going to be trading commodities, is which entity you're going to be regulated by, or if you're exempt and why you're exempt. And there's a number of different reasons why you might be exempt here. One thing that I would most definitely include in this section is some level of a risk disclosure. And I know that, this is an older document, and some of the provisions that are currently in place now were in place when this document was drafted. But right now, I would never want to put a document in front of the NFA, which is the entity that will, audit you as a commodity pool operator, that specifically says, or that says in any way, shape, or form, that there's a possibility that there may be an appreciation in your investment without directly right next to it saying, yes, but it might also go down and you might lose everything, and that there is a risk of loss. So there has to be some sort of risk disclaimer. And the NFA provides in their documents very specific wording that they want to see. And some of that should be included here. I would definitely say I would have a risk disclaimer here, and I would reference either or whether or not you have a disclosure document or a private placement memorandum, and where in those documents you can find the risks that are associated with this type of investment.
Got it. All right. Well, everybody in this owns some chunks. Sometimes you want to get rid of those. Let's jump down to 10B. It's titled Transfer. It says each limited partner expressly agrees that he will not assign, transfer, dispose of without some written notice. And then in the second paragraph, it says if the general partner receives an opinion of counsel to the effect that a transfer should be prohibited in order to protect the partnership from being treated as a publicly traded partnership, then the transfer shall be prohibited. So there's some rules in here about how the transfers of rights can happen. What do you think about this section?
So this section, it talks specifically about how you transfer your interest in your limited partnership. And it doesn't have a clear restriction on how you transfer or a clear process on how to transfer that limited partnership interest. And there's no clear mechanism there for a pre-approval of that transfer. It merely states somewhere a bit further down that you have to give notice, and it only really cites the tax classification as a reason for not approving that transfer. Generally, you would see more specific wording that any request for transfer has to be approved by the general partner, and that any substitute limited partner has to meet certain minimum requirements and specifications. And one of those reasons is the AML and KYC requirements. That's anti-money laundering and know your client requirements. And that's required by all regulatory bodies when you are taking money from the public and you're investing it on their behalf. So, and then the second thing that you would want to look at here is, again, this is a commodity pool. Is this commodity pool exempt from anything for any reason? And if they are exempt from something, then those exemptions are normally prefaced on the type of investor that you have in your fund. So if you allow in a limited partner that's not at the same status as the prior limited partner, then potentially, you can lose that exemption. But let's go back to anti-money laundering and KYC, which at the time that this document was written was not so big, but right now it's a super hot topic with both the SEC and the NFA all over this topic. And you also have a number of sanctions that have come into play that you really have to be on top of, that are recent and that were not in play at the time that this contract was written. So when you're looking at anti-money laundering consideration, you're really looking at the source of funds. And you want to know, and you have to know, essentially, if you're going to be a commodity pool operator, who the client is, how they made that money, where that money is coming from. And, you need to know that it's not tied to any terrorist activity or any criminal activity. There has to be a legal way that they made that money that they're giving to you. And also, you've got the sanctions, and there are sanctions in place under OFAC where if somebody's on that sanctions list, then you have to freeze those assets and you have to report that you have those assets. And there's a whole entire process around that. So, because there's no clear way here to for pre-approval and no clear restriction on the transfer of these limited partnership shares, you have that possibility that the first person can meet the AML requirements and then they transfer the shares to somebody who can't. And in that case, you've got a clear AML violation where one of the regulators is going to come after you. And then, also when you're looking at OFAC, again, you can't move money or transfer the ownership of money without knowing if one of those entities is on the sanctions list.
Got it. Well, one way to deal with the value of your ownership is to move it around. The other is to go cash it in. Let me go down to C in the same section, redemption. A limited partner may withdraw all or part of his capital contribution and undistributed profits, if any, from the partnership in multiples of the net asset value per unit of a class of the interest as of the last day of a month after a request has been made to the partnership. And then there's some caveats and addenda there. What do you see under redemption? Do we have the same kind of risks that you were talking about with the transfer?
Yeah, there's very similar risks here. Here I see there's a number of issues that I would change with this, and I think these are just like clear drafting issues here. I think there's a 3-day notice period. And I would have a longer notice period just so that you could. It makes the fund more solvent, I think, because it allows the fund manager to be able to create the cash value and liquidate assets enough to be able to pay that redemption back without hurting the other limited partners that are staying in the fund. And so you don't want any very large redemption to go through without thinking about how that's going to impact the other investors that are staying in the fund. And that's why you might want to have a longer notice period so you have a longer time to unwind those positions. And another thing you want to think about is if they're redeeming the total amount that they have in the fund, you don't want to just redeem all of that money out. You want to have a holdback of like 10% until you have a formal audit. Because if you give them too much money, you're not going to get that money back. You're going to be at the loss and the fund manager is going to be on the hook for that. So generally you give 90% back and you hold back 10% until there's a formal audit, until you know the exact amount of money that should be given to them. And there's one other thing that you need to consider here. You need to consider doing an AML review before you redeem that money back to the investor. So you need to make sure that nothing has changed, that the money is going straight back to the same account from which it came. Because if it's going to a different account, you need to document why. That's anti-money laundering right there. Why is it going to a different account? And you also need to check the sanctions list. Is this person affiliated with a company or are they on the sanctions list? Does that money need to be frozen? Does it need to be reported? And, again, the sanctions lists weren't in place when this document was created, but it's something that is a real risk right now.
Yeah, this is, I would assume the people who own chunks of ownership in this thing are not trying to babysit it. It's fairly hands off. And that means you need some way to get visibility. So we'll go back to 9 audits and reports to the limited partners. It says the partnership's books and records shall be audited annually by independent accountants. Each partner will receive the report within X number of days. They got to go do their tax return. And then if certain events happen, they need visibility on that. What do you see in this audit section in terms of limited partners being able to keep distance, but also know when things are on fire?
Yeah, well, here, my issue is, again, with drafting. So the rules and the regulations do say that you have to give out the audits within 90 days at the close of the fiscal year, but they do give you some wiggle room there for extensions. So, I would say as soon as reasonably practical to get those reports out, but within 90 days. hopefully within 90 days. But I wouldn't say shall, because then if you're outside of those 90 days and it's not your fault, it's the fault of your auditor, which does sometimes happen, then you're in breach of the own terms of your contract, and you don't have to be. And once you're in breach of the terms of your own contract, and then you get audited by one of the regulators, then they're going to cite you for that, and they're going to fine you for that.
Yeah. You know what I'm thinking about, Melinda, is my own insecurities. Specifically, I'm thinking about young attorneys. I have this debate with myself all the time about the idea of specialization versus, expertise versus being generally useful and knowing what questions to ask, kind of this future of what we do with lawyers. And when I go through something like this, I mean, you see so many regulations and news really coming into play. And I assume that when the person who copy-paste drafted this thing, they didn't know that there were red flags in there. This is a mentorship question, but if you're advising a young attorney who's trying to, at minimum, know where the stumbling blocks are, and maybe not own the entirety of the chunk of knowledge because it's just too big, but to be able to say, you know what, I think there's something there. Where would you tell these young lawyers to kind of keep track, keep updated? Where do they go?
I would say, first of all, when you're taking a document, you're taking somebody else's document, sure, there's lots of great phrases and sections in that document that you may want to lift out, but make sure you understand what the document says. Make sure you understand what you've lifted out, and make sure you understand what the current regulation is. Don't just wholesale take a document and just change the names and a few other things throughout. You have to read the document and actually understand what it means and what you are obligating the person that you're giving that document to do. So if you lifted this document out and you gave it to a new fund manager today, and then they got audited, they would get fined. And it would be your fault that they got fined.
Yeah. Well, obviously that's what we're trying to do with this show, is to say to people, I'm glad that you found a document on Linesider, but there's some thinking that you have to do now. We try to model that with smart people like you. So I appreciate you hanging out with us, Melinda. If people at home want to connect with you, learn more about your practice and more about agreements like this, what's the best way to connect?
Our website is www.scottgoldringassociates.com. The name of our firm, Scott Goldring Associates.
Awesome. Well,
Very
we'll have a
easy.
link to that. Yeah, we'll have a link to that in the show notes over on the blog at lawinsider.com/resources. And if you want to be a guest on the Contract Teardown Show, just email me. I'm at community@lawinsider.com. We'd be happy to have you. Again, Melinda, thank you, and we will see you all next time.
Great. Thank you so much.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.